But we truly have seen a remarkable shift in the United States due in large part to the improvement in the quality of representation in capital cases. This is not to say that capital representation in the United States is perfect by any means. There are still many lawyers being appointed who do not have the right training, who do not have the right qualifications, and who are not providing effective representation once they are appointed to represent their clients. But as a whole, if we look at the United States as a whole, the quality of representation has increased dramatically. And that means that there have been fewer death sentences. People who receive good representation at trial very rarely, if ever, receive the death penalty when their lawyers have all the training and skills and resources that they need to provide effective representation. When there are death sentences, lawyers are better trained to challenge those death sentences in the appeals and stop executions. And the drop in executions over the past several years in the United States is credited largely to the work of lawyers that have done that. States have continued to seek executions, but very few of them have been carried out because of the remarkable work of the lawyers to challenge those death sentences and argue that that the execution would violate the prisoner's constitutional rights. And as we see fewer death sentences and fewer executions, the result of that is often changes in the law. So the guidelines can be used in a number of ways to change the law. And one of the biggest is that as executions drop, as new death sentences drop, there is a reduction in the appetite for the death penalty overall. Effective capital representation is expensive. There simply is no way around that. To conduct an investigation into the facts of a crime that may be very complicated, and to investigate a person's life history going back many generations is a very expensive undertaking. And when you have a system that is so expensive and rarely used because the death penalty, there are no new death sentences, or because the death penalty is never carried out and there's never an execution, state lawmakers often change their mind. And one state we just saw that happen in is Virginia. Virginia was once one of the most active death penalty states in the United States and executed prisoners very quickly and very frequently. And this year they abolished the death penalty. There had not been an execution in Virginia for many years prior to abolition. And that is what we are seeing in the United States with abolition of the death penalty most often, is it's happening in states after they have stopped using it so frequently. And the way that we stop using the death penalty so frequently is by improving the quality of representation in these cases. One additional way that we use the guidelines to change the law is through advocacy briefs. This is something that the American Bar Association does a lot, and I think other bar associations are able to do similar things, is write briefs to the court, not when they are part of the case, but amicus briefs or friend of the court briefs, providing information to the courts and saying that we have special skill and special understanding in this area as the American Bar Association, as the creator of these guidelines, and let us help you understand why certain things are required in capital cases, why an in-depth investigation is required, why we need to develop a relationship of trust with our clients, why we need to advise our clients about the consequences of taking a plea agreement. These are all things that are covered in depth in the guidelines, and they are all things that the courts have later said have made a decision in individual cases are requirements of the law. They find a constitutional reason why these things are required, But that has come after we have written these things to the courts and explained to them what the guidelines require and why. I thought it would be a little disingenuous to talk about all these wonderful things with the guidelines without talking about a few of the challenges that we continue to face. And I've previewed that a little bit with my maps showing those states that still have not adopted the guidelines, but the challenges do go deeper than that. And I think anyone that is looking to create a set of guidelines for their own country, their own legal system, needs to, it would help to be aware of these challenges up front, so they can be anticipated. And so work can be done to try to mitigate these challenges, which will almost certainly be encountered. One of the big challenges is, of course, it's wonderful to have the guidelines written into your laws as part of your rules. That doesn't necessarily mean that that's how things are done in practice. And we see this with the courts, that you might have a rule that lawyers are required to have certain qualifications. But in practice, the courts are willing to allow lawyers who maybe fall a little bit short of those qualifications to be appointed in cases. And we see this especially in states where there are not a lot of that are less populous and where there aren't as many capital qualified lawyers. And so the courts are often willing to be more flexible in their enforcement of, or in their appointment of lawyers, flexible with the standards. And when we recently worked to get the guidelines adopted by state rule in Idaho, this was a big problem because we were told there aren't enough lawyers in the state of Idaho, which is a sparsely populated state. There aren't enough lawyers that meet the minimum qualifications of the guidelines. And so we need to lower our standards. And I pushed back very hard on that. I said, you know, the guidelines really represent the minimum of what is required for effective representation. And if the state is going to have the death penalty, they need to make sure that they have enough lawyers that meet these minimum requirements. And if they can't do that, then they shouldn't have the death penalty. So this was the argument I made, and ultimately the lawmakers agreed with this argument, and that was wonderful. But in the 3 years since then, what I've heard is that the courts are routinely saying, well, we realize these are the rules, but we still don't have enough lawyers, so we're going to appoint someone who doesn't have these qualifications. And so that doesn't mean that they failed as guidelines, but it does mean that there's more work to be done. And so that's when I go back to the agency that's responsible for appointing these lawyers and talk to them, remind them why these minimum requirements are important and why we can't fall below them. Certainly not as a routine matter. We can't fall below these standards, because if we do, that's when we start seeing all the things that Robin talked about, the wrongful convictions and the people being sentenced to death who were not eligible for a death sentence and facing wrongful execution. And so the enforcement piece, making sure that the guidelines are, if they're part of the rules, that they're enforced, really is a challenge. We've had great success with this as a model in Arizona, where we've had courts actually pull lawyers off of cases who were not meeting the performance requirements of the guidelines. And so in other states that are not doing as well with this, often I will look to Arizona and point to Arizona as an example of where lawyers are pulled off of cases when they're not doing the right thing. And that sort of enforcement is what we want to see throughout the United States. Unfortunately, that's not a universal thing, certainly not yet. We also see an issue with courts not wanting to overturn when the guidelines are used to challenge prior lawyer performance when they're used on appeal. We see courts not wanting to disturb an existing death sentence. And so this is a big challenge that we face with the guidelines, that once a death sentence is in place, courts will do everything possible to avoid reversing that death sentence and upsetting that death sentence. And so they will often admit that the lawyer's performance fell below professional norms. They will say, yes, this lawyer at trial did not do what the guidelines require. But then they will say, but it wouldn't have changed the outcome anyway. And we know that's not true. We know from our experience that isn't true. We know that when lawyers do what they're supposed to do and when they have the resources that they need to do what they're supposed to do, that it does change the outcome. But that's a much harder thing to prove, and the courts have a lot of discretion to make that judgment. And so that's an ongoing issue that we have with use of the guidelines in that way, is that it doesn't, if they aren't being enforced because the courts have decided that they don't really change anything, then it doesn't help to have them in place for review on appeal. So that's something that it's a constant battle in our work, and it's something that we expect there's going to be, there's a case that was decided by our Supreme Court just last year where the court said that counsel fell below the norms in the guidelines and the prevailing norms. And it went back down to a state court, which said, we don't agree that this was below prevailing norms, but even if it was, we're still not going to upset this death sentence. We're still not going to reverse it, even though we've been told to by our US Supreme Court, because we don't think that it would have made a difference. And so my group and others end up doing a lot of advocacy to show how the guidelines make a difference, that if people follow these guidelines, it actually does make a difference and the outcome would have changed. And so we will be using the guidelines again in those front of the court briefs, likely to go back to our US Supreme Court and ask them to again declare that this person's death sentence should be reversed. And the final challenge we face, and I'm not entirely sure how well this will translate, but this is the phrase that we hear all the time, is the Cadillac defense. And what this is referencing is, or implying, is that the guidelines represent the best of the best, the highest quality defense that a person could possibly receive, and that defendants are not entitled to this. And we have to respond that, setting aside the question of whether a defendant facing the death penalty should have the best of the best defense, which I think maybe they should, given that it's the most severe punishment that they could face. This is not what the guidelines are. They are not aspirational. They are not saying what the very best lawyer in the world would do. They're setting forth a minimum of what is required for effective representation. And no matter how many times we say this, we always have to say it again, because there is always this assumption that these are best practices, that this is what an ideal case would look like. And so over and over, I and my colleagues and Robin will say, no, this is the floor. There's a ceiling up there that's much higher, but this is the floor of what needs to be done. And if you fall below that floor, that means that this person did not receive an effective defense in their case. And often that means that their death sentence should be reversed.